under Rule 64 of the Rules of Court filed by Adelaido Oriundo, Teodoro M. Hernandez, Renato L. Bosco, Carmen Marino, and Reynaldo Salvador, former officers of the Philippine Tourism Authority who had received honoraria and cash gifts for concurrently rendering services to Corregidor Foundation, Inc. They assail the Commission on Audit's Decision No. 2010-095 dated October 21, 2010 and Resolution 3 dated December 6, 2013, disallowing the payment of the honoraria and cash gifts to them for being contrary to Department of Budget and Management Budget Circular No. 2003-5 on the payment of honoraria and Article IXB, Section 84 of the Constitution prohibiting the payment of additional or double compensation. The submissions of the parties present the following facts. Executive Order No. 58, Series of 1954, 5 made certain battlefield areas in Corregidor open to the public and accessible as tourist attractions. Executive Order No. 123, Series of 1968, FMIHR amended Executive Order No. 58, thereby authorizing the Ministry of National Defense to enter into contracts for the conversion of areas within the Corregidor as tourist spots. Pursuant to Executive Order No. 123, the Ministry of National Defense and the Philippine Tourism Authority executed a Memorandum of Agreement dated July 10, 1986 for the development of Corregidor and its neighboring islands into major tourist attractions. Specifically, the Ministry of National Defense, with prior approval of the President, leased the entire island of Corregidor to the Philippine Tourism Authority for 1 peso, PL00. As for the Philippine Tourism Authority, it undertook to maintain and preserve the war relics on the island and to fully develop Corregidor's potential as an international and local tourist destination. The Philippine Tourism Authority was thus authorized to package and source the necessary funds to develop and restore the Corregidor Island Group. On February 6, 1987, the Philippine Tourism Authority Board of Directors adopted Resolution No. B7-87, approving the creation of a foundation for the development of Corregidor. On October 28, 1987, the Corregidor Foundation, Inc. was incorporated under Securities and Exchange Commission Registration No. 145,674. On August 3, 1993, the Philippine Tourism Authority executed a Memorandum of Agreement with Corregidor Foundation, Inc. to centralize the island's planning and development. The Philippine Tourism Authority agreed to release to the Corregidor Foundation, Inc. its operating funds based on a budget for its approval. For its part, the Corregidor Foundation, Inc. agreed to submit a quarterly report on the receipts and disbursements of Philippine Tourism Authority funds. It additionally agreed to deposit all collections of revenues in a distinct and separate account in the name of the island of Corregidor, with the disposition of the funds at the sole discretion of the Philippine Tourism Authority. Another Memorandum of Agreement was subsequently entered into by the Philippine Tourism Authority and the Corregidor Foundation, Inc. on September 3, 1996. The subsequent agreement reiterated the provisions of the August 3, 1993 agreement but added some stipulations. In particular, the second paragraph of Item 4 was included, providing that the disbursements of the Philippine Tourism Authority's funds by Corregidor Foundation, Inc. shall be subject to the audit of the internal auditor of the Philippine Tourism Authority and the Commission on Audit. The audit team thus recommended that Corregidor Foundation, Inc. comply with Budget Circular No. 2003-5, otherwise, it would be constrained to recommend the disallowance of the amounts paid as honoraria and cash gift. On June 15, 2006, the Legal and Adjudication Office Corporate of the Commission on Audit issued Notice of Disallowance No. CFI 2006-001, disallowing in audit the honoraria and cash gift paid to Oriundo, Hernandez, Bosco, Marino, and Salvador. Aside from the payees, the persons made liable for the amount were Corregidor Foundation, Inc.'s Chief Accountant Noria Jane Perez, Finance Office Laurel Legazpi, and Executive Director Artemio G. Matabag. Oriundo, Hernandez, Bosco, Marino, and Salvador filed a motion for reconsideration of the Notice of Disallowance, arguing that Corregidor Foundation, Inc. is a private corporation created under the Corporation Code and, therefore, cannot be audited by the Commission on Audit. This was denied by the Legal Adjudication Office Corporate in its decision No. 2007-037, where it held that Corregidor Foundation, Inc. is a government-owned or controlled corporation. The appeal filed was likewise denied by the Adjudication and Settlement Board of the Commission on Audit in Decision No. 2009-002. Citing the definition of a government-owned or controlled corporation in the Administrative Code of 1987, the Adjudication and Settlement Board held that Corregidor Foundation, Inc. is a government-owned or controlled corporation under the audit powers of the Commission on Audit. Corregidor Foundation, Inc., according to the Adjudication and Settlement Board, is a non-stock corporation which receives funds from the government, through the Philippine Tourism Authority. The Adjudication and Settlement Board highlighted that Memorandum of Agreement dated September 3, 1996 provided that the funds received and disbursed by the Corregidor Foundation, Inc. is subject to the audit of the Internal Auditor of the Philippine Tourism Authority and the Commission on Audit. Finally, Corregidor Foundation, Inc. was deemed created for a public purpose, which is the maintenance and preservation of Corregidor. Considering that Corregidor Foundation, Inc. is a government-owned or controlled corporation, the Adjudication and Settlement Board held the foundation is subject to Budget Circular No. 2003-5 and 2003-02, limiting the grant of honoraria to specific government personnel, and Article IXB, Section 8 of the Constitution prohibiting double compensation. The dispositive portion of the Adjudication and Settlement Board's Decision No. 2009-002 read, "Wherefore, the foregoing premises considered, the issues for this Court's resolution are, first, whether or not the Commission on Audit has jurisdiction to determine whether a corporation such as Corregidor Foundation, Inc. is a government-owned or controlled corporation, and second, whether or not Corregidor Foundation, Inc. is a government-owned or controlled corporation under the audit jurisdiction of the Commission on Audit. Board hereby denies the instant appeal for want of merit." Accordingly, Corporate Decision No. 2007-037 dated June 7, 2007 sustaining ND No. CFL 2006-001 dated June 15, 2006 is affirmed. Emphasis in the original, Oriendo, Hernandez, Bosco, Marino, and Salvador appealed Decision No. 2009-002, but the appeal was denied by the Commission on Audit in its October 21, 2010 Decision No. 2010-095. The issues for this Court's resolution are, first, whether or not the Commission on Audit has jurisdiction to determine whether a corporation such as Corregidor Foundation, Inc. is a government-owned or controlled corporation, and second, whether or not Corregidor Foundation, Inc. is a government-owned or controlled corporation under the audit jurisdiction of the Commission on Audit. The petition is dismissed. Respondent Commission on Audit did not gravely abuse its discretion in issuing notice of disallowance No. CFI 2006-001. It has the competency to determine the status of corporations such as Corregidor Foundation, Inc. as government-owned or controlled, and correctly found that Corregidor Foundation, Inc. is, indeed, a government-owned or controlled corporation under its audit jurisdiction. We first address Respondent Commission's contention that petitioners erroneously referred to their petition as a petition for review on certiorari under Rule 64 of the Rules of Court. A petition for review on certiorari is the remedy provided in Rule 45, Section 1 of the Rules of Court against an adverse judgment, final order, or resolution of the Court of Appeals, the Sandiganbayan, the Regional Trial Court or other courts whenever authorized by law. Rule 45 Appeal by certiorari to the Supreme Court Section 1. Filing of petition with Supreme Court. A party desiring to appeal by certiorari from a judgment or final order or resolution of the Court of Appeals, the Sandiganbayan, the Regional Trial Court or other courts whenever authorized by law, may file with the Supreme Court a verified petition for review on certiorari. The petition shall raise only questions of law which must be distinctly set forth. On the other hand, Rule 64 of the Rules of Court pertains to a review of judgments and final orders or resolutions of the Commission on Elections and the Commission on Audit. Section 1 of Rule 64 defines the scope of the rule, while Section 2 refers to mode of review and provides that the judgments, final orders, and resolutions of the Commission on Audit are to be brought on certiorari to this Court under Rule 65. The pertinent provisions of Rules 64 and 65 are as follows. Rule 64 Review of judgments and final orders or resolutions of the Commission on Elections and the Commission on Audit. Section 1. Scope. This rule shall govern the review of judgments and final orders or resolutions of the Commission on Elections and the Commission on Audit. Section 2. Mode of review. A judgment or final order or resolution of the Commission on Elections and the Commission on Audit may be brought by the aggrieved party to the Supreme Court on certiorari under Rule 65, except as hereinafter provided. Section 3. Time to file petition. The petition shall be filed within 30 days from notice of the judgment or final order or resolution sought to be reviewed. The filing of a motion for new trial or reconsideration of said judgment or final order or resolution, if allowed under the procedural rules of the Commission concerned, shall interrupt the period herein fixed. If the motion is denied, the aggrieved party may file the petition within the remaining period, but which shall not be less than 5 days in any event, reckoned from notice of denial. Rule 65 Certiorari, Prohibition, and Mandamus. Section 1. Petition for certiorari. When any tribunal, board, or officer exercising judicial or quasi-judicial functions has acted without or in excess of its or his jurisdiction, or with grave abuse of discretion amounting to lack or excess of jurisdiction, and there is no appeal, or any plain, speedy, and adequate remedy in the ordinary course of law, a person aggrieved thereby may file a verified petition in the proper court, alleging the facts with certainty and praying that judgment be rendered annulling or modifying the proceedings of such tribunal, board, or officer, and granting such incidental reliefs as law and justice may require. The petition shall be accompanied by a certified true copy of the judgment, order, or resolution subject thereof, copies of all pleadings and documents relevant and pertinent thereto, and a sworn certification of non-forum shopping as provided in the paragraph of Section 3, Rule 46. Section 4. Where petition filed. The petition may be filed not later than 60 days from notice of the judgment, order, or resolution sought to be assailed in the Supreme Court or, if it relates to the acts or omissions of a lower court or of a corporation, board, officer, or person, in the regional trial court exercising jurisdiction over the territorial area as defined by the Supreme Court. It may also be filed in the Court of Appeals whether or not the same is in aid of its appellate jurisdiction, or in the Sandiganbayan if it is in aid of its jurisdiction. If it involves the acts or omissions of a quasi-judicial agency, and unless otherwise provided by law or these rules, the petition shall be filed in and cognizable only by the Court of Appeals. The foregoing provisions readily reveal that a petition for review on certiorari under Rule 45 is an appeal and a true review that involves digging into the merits and unearthing E1tors of judgment. However, despite the repeated use of the word review in Rule 64, the remedy is principally one for certiorari that deals exclusively with grave abuse of discretion, which may not exist even when the decision is otherwise erroneous. That the remedy against an adverse decision, order, or ruling of the Commission on Audit is a petition for certiorari, not review or appeal, is based on Article IXA, Section 7 of the Constitution. Thus, Article 9 Constitutional Commissions A Common Provisions Section 7. Each commission shall decide by a majority vote of all its members any case or matter brought before it within 60 days from the date of its submission for decision or resolution. A case or matter is deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of the Commission or by the Commission itself. Unless otherwise provided by this Constitution or by law, any decision, order, or ruling of each Commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt of a copy thereof. Emphasis supplied. This is affirmed in Reina v. Commission on Audit, where the Court maintained its certiorari jurisdiction over judgments, final orders, or resolutions of the Commission on Audit. In the absence of grave abuse of discretion, questions of fact cannot be raised in a petition for certiorari, under Rule 64 of the Rules of Court. The office of the petition for certiorari is not to correct simple errors of judgment. Any resort to the said petition under Rule 64, in relation to Rule 65, of the 1997 Rules of Civil Procedure is limited to the resolution of jurisdictional issues. 58. We agree with Respondent Commission that petitioners erroneously denominated their petition as a petition for review on certiorari. Except for the designation, however, we find that the petition was filed under Rule 64 of the Rules of Court, given that the petition refers to Rule 64 and was filed within 30 days from notice of the resolution dated December 6, 2013, denying petitioner's motion for reconsideration before the Commission on Audit. Therefore, we shall resolve the petition in the exercise of our certiorari jurisdiction under Article IXA, Section 7 of the Constitution. The Constitution, the Administrative Code of 1987, and the Government Auditing Code of the Philippines define the powers of the Commission on Audit. Article IXD, Section 2 of the Constitution provides, Section 2. 1. The Commission on Audit shall have the power, authority, and duty to examine, audit, and settle all accounts pertaining to the revenue and receipts of, and expenditures or uses of funds and property, owned or held in trust by, or pertaining to, the government, or any of its subdivisions, agencies, or instrumentalities, including government-owned or controlled corporations with original charters, and on a post-audit basis, a. Constitutional bodies, commissions and offices that have been granted fiscal autonomy under this Constitution, b. Autonomous state colleges and universities, c. Other government-owned or controlled corporations and their subsidiaries, and d. Such non-governmental entities receiving subsidy or equity, directly or indirectly, from or through the government, which are required by law or the granting institution to submit to such audit as a condition of subsidy or equity. However, where the internal control system of the audited agencies is inadequate, the Commission may adopt such measures, including temporary or special pre-audit, as are necessary and appropriate to correct the deficiencies. It shall keep the general accounts of the government and, for such period as may be provided by law, preserve the vouchers and other supporting papers PE1 ironing thereto. 2. The Commission shall have exclusive authority, subject to the limitations in this article, to define the scope of its audit and examination, establish the techniques and methods required therefor, and promulgate accounting and auditing rules and regulations, including those for the prevention and disallowance of irregular, unnecessary, excessive, extravagant, or unconscionable expenditures, or uses of government funds and properties. Emphasis supplied, a provision similar to Article IXO, Section 2, 1, is found in Book V, Title I, Subtitle B, Chapter 4, Section 11 of the Administrative Code, Section 11. General Jurisdiction. L. The Commission on Audit shall have the power, authority, and duty to examine, audit, and settle all accounts pertaining to the revenue and receipts of and expenditures or uses of funds and property, owned or held in trust by, or pertaining to, the government, or any of its subdivisions, agencies, or instrumentalities, including government-owned or controlled corporations with original charters, and on a post-audit basis, a. Constitutional bodies, commissions and offices that have been granted fiscal autonomy under this Constitution, b. Autonomous state colleges and universities, c. Other government-owned or controlled corporations and their subsidiaries, and d. Such non-governmental entities receiving subsidy or equity, directly or indirectly, GOM or through the government, which are required by law or the granting institution to submit to such audit as a condition of subsidy or equity. However, where the internal control system of the audited agencies is inadequate, the Commission may adopt such measures, including temporary or special pre-audit, as are necessary and appropriate to correct the deficiencies. It shall keep the general accounts of the government and, for such period as may be provided by law, preserve the vouchers and other supporting papers pertaining thereto. Emphasis supplied, the Government Auditing Code of the Philippines, in Section 26, likewise provides, Section 26. General Jurisdiction. The authority and powers of the Commission shall extend to and comprehend all matters relating to auditing procedures, systems, and controls, the keeping of the general accounts of the government, the preservation of vouchers pertaining thereto for a period of 10 years, the examination and inspection of the books, records, and papers relating to those accounts, and the audit and settlement of the accounts of all persons respecting funds or property received or held by them in an accountable capacity, as well as the examination, audit, and settlement of all debts and claims of any sort due from or owing to the government or any of its subdivisions, agencies and instrumentalities. The said jurisdiction extends to all government-owned or controlled corporations, including their subsidiaries, and other self-governing boards, commissions, or agencies of the government, and as herein prescribed, including non-governmental entities subsidized by the government, those funded by donations through the government, those required to pay levies or government share, and those for which the government has put up a counterpart fund or those partly funded by the government. Emphasis supplied. In Republic Act No. 10,149, otherwise known as the GOCC Governance Act of 2011, the term is defined in Section 3, Section 3. Definition of terms. Government-owned or controlled corporation, GOCC, refers to any agency organized as a stock or non-stock corporation, vested with functions relating to public needs whether governmental or proprietary in nature, and owned by the government of the Republic of the Philippines directly or through its instrumentalities either wholly or, where applicable as in the case of stock corporations, to the extent of at least a majority of its outstanding capital stock, provided, however, that for purposes of this Act, the term GOCC shall include GICP/GCE and GFI as defined herein. Based on the above provisions, an entity is considered a government-owned or controlled corporation if all three attributes are present. L. The entity is organized as a stock or non-stock corporation. 65. 2. Its functions are public in character. And 3. It is owned or, at the very least, controlled by the government. Examples of government-owned or controlled corporations are the Leyte Metropolitan Water District and the Boy Scouts of the Philippines. As found in Feliciano, the Leyte Metropolitan Water District is a stock corporation organized under an original charter or special law, i.e., Presidential Decree No. 198 or the Provincial Water Utilities Act of 1973. It performs a public service by providing water to its water district and, as a local water utility, it is controlled by the government considering that its directors are appointed by the head of the local government unit. It was in Feliciano where this Cami said that the determining factor of the Commission on Audit's audit jurisdiction is government ownership or control of the corporation. As for the Boy Scouts of the Philippines, this Comey held in Boy Scouts of the Philippines v. Commission on Audit 70 that it is a non-stock corporation created under an original charter, specifically, Commonwealth Act No. 111. Its functions primarily involve implementing the state policy provided in Article 2, Section 13 of the Constitution on promoting and protecting the well-being of the youth, and that it is an attached agency of the then Department of Education, Culture, and Sports, now Department of Education. XXX Corregidor Foundation, Inc. was organized primarily to maintain and preserve the war relics in Corregidor and develop the area's potential as an international and local tourist destination. Its Articles of Incorporation provides the following purposes. Second, that the purposes for which the foundation is formed are as follows: 1. To maintain and preserve war relics on Corregidor Island and the development of its potentials as an international and local tourist destination, and to that end and purpose, to promote and encourage the recovery, collection, preservation, restoration, and protection of materials and objects, including land and buildings, forming part or otherwise depicting the historic character and role of the island fortress in the defense of the country's territorial integrity and sovereignty, such as but not limited to maps, sketches, drawings, flags, documents, books and military armaments, equipment, and facilities. 2. To enter into, make, perform and carry out of, cancel and rescind contracts of every kind and for any lawful purpose with any person, firm, association, corporation, entity, domestic or foreign, or others, in which it has a lawful interest. 3. To acquire, purchase, own, hold, operate, develop, lease, mortgage, pledge, exchange, sell, transfer, or otherwise in any manner permitted by law, real and personal property of every kind and description or any interest therein as may be necessary to carry out its purposes. 4. To raise or borrow money for any of the purposes of the foundation and from time to time without limits as to amount to draw, make, accept, endorse, guarantee, execute and issue promissory, notes, drafts, bills of exchange, warrants, debentures, and other negotiable or non-negotiable instruments and evidence of indebtedness, and to secure the payment thereof, and of the interest thereon by mortgage on, or pledge, conveyance or assignment in trust of the whole or any part of the assets of the foundation, real, personal, or mixed, including contract rights, whether at the time owned or thereafter acquired, and to sell, pledge, or otherwise dispose of such securities or other obligations for the foundation and furtherance of its purposes. 5. To invest funds as it may be able to obtain from donations, grants, or loans and from all other sources, in securities or properties from the return of which the foundation hopes to subsist and carry on the activities and purposes for which it was organized. 6. In general, to carry on any activity and to have and exercise any and all of the powers conferred by law, and to do any and all acts and things herein set forth to the same extent as juridical persons could do, and in any part of the world, as principal, factor, agent or otherwise either alone, or in syndicate, partnership, association, or corporation, domestic or foreign, and to establish and maintain offices and agencies and to exercise all or any of its corporate powers and rights within the Philippines or abroad, as may be directly or indirectly incidental or conducive to the attainment of the above-mentioned purposes.